Now, you mentioned as one of your responsibilities, the large part of your responsibility was the scheduling and the appointment of panels of judges to hear appeals. Can you tell us a little bit about that?
Typically, we sit in panels of 3 on an appeal, and occasionally we sit with panels of 5, but never more than that. The rule is that the majority rules, so that if there's a 3-person, 3-judge panel, you can have a dissent, but the majority 2 decision will govern the case. What we do is we schedule a panel to sit together for a week. Typically during a week, a panel would hear anywhere from 10 to 15 appeals. Immediately after hearing an appeal, the panel adjourns. They consider the case. If it's a case that can be decided at that time, the court will return, deliver its decision with its reasons. If, on the other hand, it's more complicated, then the court will reserve its judgment and render written reasons and decision sometime in the future.
Okay, when you appoint a panel, whether it be 3 or 5, do you appoint someone who has to write up the decision, or do they decide amongst them who will write the decision?
They decide amongst themselves who will write the decision. And we appoint our panels randomly, so we don't try to assign judges to a particular type of case. The goal in assigning judges is actually to have each judge sit with as many other judges on a panel during the course of a given year.
In all your time, have you ever had to recuse yourself from an appeal because of some kind of conflict of interest?
Yeah, a couple times I have. If a case comes before the court for a client for whom I'd acted in recent years when I was practicing, I have on occasion. There are a couple of lawyers with whom, a couple of my junior lawyers when I practice, with whom I have a close enough relationship. They were really my mentees, that I don't hear appeals if they're arguing them.
Okay. And what percentage? You said you hear between 1,200 and 2,000 appeals.
1,000 to 1,200.
1,000 to 1,200 in the province. What percentage of those would go further to the Supreme Court of Canada?
Well, cases can get to the Supreme Court of Canada 2 ways. If there's a dissent in our court, there's an automatic right to an appeal in the Supreme Court of Canada. Failing that, if they have to get leave from the Supreme Court of Canada to hear the appeal. The Supreme Court of Canada has to agree to hear the appeal. From Ontario, in a normal year, the Supreme Court of Canada would hear probably 20 to 25 appeals. So out of the 1,000 or 1,200 appeals that we decide, that many would be heard by the Supreme Court of Canada, and then of those, they might uphold the decision or overturn the decision. I'm not sure what the percentages are.
Do you or do any of the judges on your court, or even justices associated with the Superior Court of Ontario, do you ever feel worried that you're going to be overturned in your decision, or is that pretty much an automatic part of the job? You make your decision based on what you have, and it doesn't bother you where it goes from there?
I think ideally that's the way it should work. It goes with the territory. Judges are going to be overturned from time to time. I suppose it's never particularly pleasant to be told that somebody disagrees with you, but I don't think many judges unduly fuss with the fact that they might be overturned, or indeed when they are overturned, get too terribly bent out of shape about it.
Okay, so let's say you get a case coming up from the Superior Court, and you only hear that case if there is A, new evidence, or B, the trial judge has made an error in applying the law or interpreting the law. Is that correct?
I'd say we only interfere. We only allow an appeal for basically in one of two situations. I'll oversimplify again, if the trial judge in the court below has made an error in law, if we think it's an error in law, and the error in law is sufficiently serious that it could have affected the outcome of the case, we will interfere. Okay, so not all errors in law will be that serious. Secondly, the court and the judge below makes findings of fact and makes any number of discretionary decisions, imposing a sentence, fixing the amount of an award of damages, fixing spousal support. And those types of decisions where a trial judge has a discretion, we only interfere if we think the decision was unreasonable. So even though a court of appeal might have reached a different conclusion on the point, with a discretionary decision, it must be, in our view, outside the bounds of what's reasonable before we interfere.
Okay, so with regard to the deference concept, am I correct in assuming that the Court of Appeal always gives deference to the judgment made by the Superior Court judge or whoever is bringing the appeal when one of those cases that you mentioned?
Yeah, another way of putting what I said is the Court of Appeal shows deference to the court below on findings of fact, the way they found the facts, or on any discretionary decision, like imposing a sentence, as I say, a custody award, and so on. And showing deference means that we will not interfere with it, even though we disagree with it, unless we think it's unreasonable. That's deference. On the other hand, if it's a mistake of law, we don't show deference. We apply a test of correctness. Was it right or was it wrong?
Okay, the differences that come to mind, I was reading one case that occurred in Northern Ontario where a police officer was found by the trial judge to have seriously breached the rights of a car that he stopped, and then proceeded to search the car and found a quantity of illegal drugs. And the trial judge wrestled with whether or not he should enter the evidence or exclude it. Can you explain the difference between whether the evidence should be included, as opposed to in the U.S., if it's deemed that the search was illegal, the evidence is automatically excluded? Am I correct in that?
Well, in the U.S., there are qualifications to the automatic exclusion, but but in Canada, under our Charter of Rights, even if evidence is found to have been obtained in breach of the Charter, it can still be admitted into evidence if, and this is the important part, if the benefit to the administration of justice would be greater by admitting the evidence than excluding it, or if the prejudice to the administration of justice would be greater by excluding it rather than admitting it. So that what the trial judge has to do is say, okay, there's been a charter breach. He has to weigh how serious that charter breach is against the damage to the administration of justice by either admitting the evidence or excluding the evidence. So there's a weighing test that has to go on by the trial judge.
But that still leaves room for his decision to be overturned if it goes all the way to the Supreme Court and they rule that there was a breach in his Charter of Rights and Freedoms, then they would overturn any decision to...
Not necessarily. They would defer to his decision if they thought his decision was reasonable.